report. Live. Be seated.
Ladies and gentlemen, we have discussed with the Chief Justice during the reset and continuation of this matter. We will begin jury selection in Miami on the morning of June 25th. And it'll be in the Justice Building. It's 1351 Northwest 13th Street, I believe. Courtroom 4-1. It'll be noted, I've already talked to the administrative judge there and my secretary. Everything will be ready to go. And I want you to prepare sufficient order, Mr. Harvey, one of you, for the change of venue. In discussing the matter with the Chief Justice, he instructs me that whatever orders you need for your transfer of authority, Mr. Morrison, you'll be plentiful with it. Or Mr. Harvey, one of you will be acquainted for your particular divisions to go ahead and prepare it, and it'll be taken care of.
Judge, I would ask the court if we anticipate at this point there'll be a problem in just in the physical aspects of getting all the files and everything down there, place to live or stay.
Well, I don't think there'll be any problem with that. It's got more than one hotel.
Yes, sir.
There's 2 or 3 little corners we can store files in, and anything you need.
Yes, sir. I would just ask the court if it wouldn't be possible to start jury selection first part of July.
Well, that comes into a holiday. The 4th is in the middle of the week, and I think that
I was just
you
thinking.
got a week and a weekend and 4 days, and I'm still dedicated to that midnight oil, Mr. Harvey.
Yes, sir. I understand.
Even weekend oil.
I was just
But
thinking.
I think we can get the things keyed off. I've got it set in gear for that and informed him as the 25th. I still will give all the latitude that I can concerning the time factor, but I think the 25th is a reasonable time now. And we're going to anticipate it kicking off at that time. We can begin I think our voir dire will be shortened a little bit about venue anyway. So I think your preparation is well done, and if we let it go too long, we'll fall off of this crest that we always get to as we approach trial. Court's been there many times. I know what you're talking about.
I was thinking.
I think we can be ready, and my office and my secretary and anything that we can assist in accommodations or any of those things, I want you to know will be available.
Thanks.
There is a Holiday Inn within a very short distance of the Justice Building, 2 or 3 blocks. 2 blocks. I think it's called a Civic Center Holiday Inn. I'd suggest you contact them for reservations. I think the delay between then and now is reasonable. You've got and I don't mean by saying that I'm pushing them. I just have to be the closest place. You understand?
Yes.
Program, so I don't have to get involved. But I think if you will inquire, you'll find it probably the closest. But we will grant your motion, and I want you to prepare an order consistent with what we've done and set the trial in Miami pursuant to the rule beginning on the morning of the 25th. All right, this court will be in recess. Till then.
Hear ye, hear ye, hear ye. This Honorable Circuit Court of the 11th Judicial Circuit of Florida in Presiding County is now open. All persons having business before this court, draw nigh, give attention, and ye shall be heard. God save the state of Florida, this honorable state. God save the state of Florida, this honorable state, the honorable Judge Cowart presiding. Please be seated, court will come to order. Mr. Harvey, I think you have filed some matter of motion for the court clerk to consider.
Yes, sir. Additionally, what I'd like to introduce Robert Haggard. We have invited him to participate in today's, for this case, only special assistant.
Welcome, Mr. Haggard.
Thank you. It's my pleasure.
He's an old timer to the circuit, so we don't have a problem. You made a good choice.
Thank you. Also, if you guys like to present Mr. Neil Spielman, who's going to participate in consultant with jury selection. I'd like to present before this law, please.
Gaber?
Just on the Haggard thing, Judge, I'm sure the court is familiar with him because he's local, but we don't really know Mr. Haggard. Is he a member of the Florida Bar?
Yes.
And on this fellow, Judge, I don't believe we'd argued that motion yet. Hopefully, we're not going to make a decision until we argue. The expert for jury selection.
Depending on that. You just gonna have his presence or what is it?
Rather than being away from great to get here and consult with us, we do have a motion pending before the court for other than.
Well, let me indicate to you, Mr. Spillman, you may be able to.
Thank you.
You may be seated. I think maybe we can take that motion up now, Mr. Harvey. First of all, prior to it, Madam Clerk, I have exhibits that wandered into my collection from Tallahasse, and these are on the motion for change venues, which we've heard but should be filed in files. Then it's 18, 19, 20, and 21. I'll file them with this time. These are copies, I think. I don't know whether they were marked, so they should be in the file. All right, your first motion then is you've got an appointment with jury expert. Let me hear you on your motion.
Yeah, we just simply, we do need to have an expert consultant injury selection. Mr. Spielman is very qualified. He's often come down and he help us out at a very big rate as to what the usual fees are. Appreciate it.
That is for your consultation only?
Yes.
Mr. Keever?
Judge, we just reached the point where it's such a luxury to be a public defender on this case. It's unbelievable.
You know, someday you might be further on, Mr. Keever. Maybe you'll follow.
I might be, Judge, but honestly now, jury selection is something a public defender with Mr. Harvey's qualifications and Mr. Haggard's certainly an expert in it. That's supposed to be something they do for a living, is picking juries. And I'm sure every public defender in the state would like to have the benefit of an expert such as this man sitting here. But we don't appoint him in every picking case, and I don't think we should in this one, Judge.
Well, I'm not going to raise the gentleman to any appointment status, but if you want to confer with him during the course of the proceeding, you may feel free to do so. Don't mean by that he can question any juror, but if you need to consult with him, you may feel free to do so. During the course of the binary selection, he may stay forward of the bar. After the completion of that, he will present himself in the same way. Now, that's not to say I'm proving any payment. I'll talk about that with you later.
We'll be able to raise that issue.
Yes, sir. I'll let you raise the issue later.
Your Honor, I raise an issue that is commensurate and collateral to this issue, and it is the position of the counsel table. Generally, it is my feeling that the accused should always have the fullest right to communicate, and we do communicate aside from speech, we communicate by gesture and expression. And part of and necessary to the effective assistance of Dr. Spielman would be a position in the courtroom where we would be in a posture to receive the most effective communication with the jury. And that is why I would ask the court if we could have the counsel table closest to the jury.
Well, if we have to depend on facial gestures and that type of stuff and convincing juries, the public defender system is a problem. So this court is going to come from my witness stand. I can appreciate it. I want to give you free access to everything there is in the courtroom. No priority is where people are sitting as far as the court is concerned. to let the record reflect that you will be in direct line of the jury's vision. There's no obstruction, and there's nothing out of that matter. I would deny that motion, and we'll remain where we're seated, consistent with what we've always done. And now, Madam Clerk, here is another motion that was in pro se filed before me at Leon County. I filed. Yeah, I think I have the original of the motion of expert, which I'll file with you, that was transmitted to me by Good. Now, have you filed the original, or is this the original?
Judge, you said you were copy. We should file it.
Those things are filed, and if you don't have them, Madam Clerk, I have a copy. If you want to retain that copy, that's fine. What other motions do we have in preparation?
Yeah, Bundy has put some.
All right.
I don't know if we have a copy of it, Judge.
You don't have a copy of it, Mr. Keever. I don't have a copy of the facility of my jail cell in Dade County Jail.
Judge, I'm not speaking to Mr. Bundy, and I appreciate it if we follow the rules of evidence when we're handling
Well, we are going to not consider a motion if you haven't provided a copy of it. Let him see your motion, and then you may present that.
Thank you, Your Honor. I was going to bring that issue up to the court because that is one of the questions I think we have to consider.
You may speak on the motion as they read it, and I will see the written motions, and you may proceed.
Thank you, Your Honor. As the court knows, I was being held in the Leon County Jail in Tallahasse, Florida, during the time the venue was in Leon County, and was transferred only yesterday to Dade County Jail in preparation for the proceedings this morning. In preparation for my transfer, I was informed by the Leon County Sheriff as to what items of my personal property that I could bring and what items I could not bring. And I was informed by the sheriff, was in fact the case, that I was only allowed to bring files directly related to the crime mega case and clothing. Not allowed to bring with me any legal files or any legal materials or any legal source books. I might inform the court, for instance, in that category of things I was not allowed to bring was the Florida Rules of Criminal Procedure law, basic text. I was not allowed to bring typewriter. I was not allowed to bring stationery. I was not allowed to bring pencils, pens, envelopes, pens, or anything with which I could prepare, otherwise participate in this. It's only through a last-minute gift from my attorney last evening that I was able to get a hold of the pen to write the motion with the county court for today. Not allowed to bring with me my files in the Lake City case, which, in the absence of those files, would preclude me from conferring with Mr. Alcantara, who was recently appointed to represent me in that matter. I was not allowed to bring with me legal files concerning collateral acts that the state intends to introduce in this proceeding, such as involving credit card transactions, or those legal files dealing with the theft of a white van, which may or may not be a collateral act in this case. Upon arriving in Miami and being booked in the Dade County Jail, I was taken to the fourth floor and spoken to by Sergeant Kratz at the Dade County Jail. And after Sergeant Kratz informed me of the rules and regulations of the jail, I was placed in a isolation cell, also known as a strip cell, also known as a punishment cell. The cell is approximately 9 feet by 7 feet. It's illuminated by a light source which is well outside the cell and must filter through the steel bars into my cell. It has a shower stall and a bunk and a stool and a table built into the side of the cell wall. For all practical purposes, Your Honor, the cell effectively frustrates my ability to participate in my own from the preparation of my own defense, since the light source is totally inadequate to read by. The only way one can read in that cell is to hold the document outside the bars and read the document with the available light that filters from the light source outside the cell. The picture on the stool is totally inadequate. It's designed for right-handed people, and I unfortunately have the handicap of being left-handed. There's no way you can write on that stool and table being left-handed. There's a further question as to what I'll be allowed to have in my cell and whether or not I'll exercise. Your Honor, considered individually, perhaps my complaints may seem insignificant, but I would ask the court to consider it in their totality, their impact on my ability to cooperate with counsel and participate with counsel. I might also say that because the Leon County Sheriff's Department waited until literally the last moment to bring me down here, I have not had an opportunity to fully discuss with counsel the proceedings which will take place today. And I will also state for the record and inform the court that since the change of venue ordered by this court in Tallahassee, I don't know, I guess it was 10 days ago or 2 weeks ago, I have been able to consult with my counsel a total of approximately 3 hours, and they came by last night at the top. I feel that with the amount of time that my counsel had access to me in these past 2 weeks, we have not been able to work together. They have not been able to inform me as to the course of the defense, both prior to the selection of the jury and during the selection of the jury, and for that matter, during the trial itself. And I will inform the court that one of my complaints that I voiced to Your Honor in Tallahassee was that I did not know, and I still do not know, any of the names of the witnesses we're going to be calling, what we're supposed to get out of those witnesses, what part I'll play, if any, examination of those witnesses, and so on. I don't think this is because my counsel don't want to tell me. They've been pretty darn busy. They've been so busy chasing their tails on this, they haven't had time to talk to me. And I think that the very nature of that limitation is also a limitation on and my effectiveness as a defender. What in the world can I add to a defense I don't know anything about? This is what, Your Honor, the Coretta Court, United States Supreme Court, was addressing itself to when they said that a defendant of the right granted by the Sixth Amendment is a right granted personally to a defendant, that the state cannot force upon a defendant a defense which she does not want. And I would say that by implication, the state cannot force upon a defendant a defense he has no knowledge of and no participation in the creation.
And I understand the scope of your motion.
Okay. Let me simply say that the relief I request in that motion is the return of legal documents, the improvement of lighting, exercise, and a number of other things I'd like the court to consider and rule on at the earliest possible option. And there's also a motion, if I'm not mistaken, for the court by Ms. Druid, a motion to continue based upon, in part, our inability to confer with one another.
Mr. McCabe?
Well, it sounds to me mostly like those in-house things, Judge, that can be worked out with the jail personnel and Mr. Harvey or whoever wants to bring it to the court's attention. I feel like we've already argued this thing in Tallahassee about how much assistance he's got a right to and what kind of counsel and all that stuff. So I'm not going to belabor the court with the same arguments I've already made. I just think we can work this stuff out in-house.
All right, on this defendant's motion, the court's going to take it under advisement. The noon recess, I'll personally visit where you're incarcerated, and I'll make a decision based upon that. We'll see what's there.
Thank you.
You may file this, Madam Clerk. So you want to take the motion to continue now, Ms. Good?
Yes, Your Honor. We filed a motion to continue on the grounds, as Mr. Bundy has stated, that we have had an inadequate opportunity to confer with the defendant. We did meet with him on Saturday, June 16th, after we changed the venue on the 12th. On the 20th, the defendant was transported to Columbia County. I attempted to make arrangements to visit with Mr. Bundy that evening when he returned at about 6:30, and Mr. Art Bolden told me that it would not be possible for me to visit with Mr. Bundy that evening. I attempted to visit with him on the morning of the 21st, so that was just a very brief conference. And as you notice, I have had to scratch out part of the motion on the original there, because although we intended to confer with Mr. Bundy again this morning, we were not able to. We were informed by the jail that problems with transportation and his recent arrival, that they just hadn't worked out the logistics of that yet, and therefore we really feel unprepared to proceed today with jury selections, and would request an adequate period of time to confer with the defendant.
What do you want to confer with him about on jury selection, Ms. Good?
Your Honor, it's representing himself here as co-counsel, and we do have an expert in jury selection that we're conferring with. And there are matters that we do need to talk to him about and determine concerning the jury selection procedure.
All right. Anything from the state?
Again, Judge, I've already argued this motion. They've had 6 months since they were appointed in January. They started picking a jury in Tallahasse, and I presume at that time that they had conferred with them and had a feeling for what they wanted in a jury. Now here we are again 2 weeks later in Miami with the same general situation of picking a jury.
Your Honor, in Tallahassee, we also had a pending motion to continue that was denied, and we were totally unprepared for that voir dire. And very luckily, venue was changed.
Wasn't lucky. It was legally.
Well, luckily and legally, luckily for us, we've had perhaps 10 more days to try and prepare. But as you know, the arrangements to transfer to Miami have been involved. So we haven't been able to devote all of our time to merely preparation for trial where we were unprepared before. And these matters do.
How much time you think you need?
No, I think we need it at least a day.
All right. Let the record reflect the motion came on to be heard. The motion in its totality will be denied, but I'll extend the noon lunch hour for a period of time for us to visit the jail and for them to discuss further the jury selection process with Mr. Bundy. We'll be in noon recess on the matter until from 12 till 2:30. That'll give you 2.5 hours. And we'll make arrangements to have him available for you to talk with him. Preliminary discussion with juries during the morning concerning minimum qualifications are standard and not intrinsic or unique to this particular case, and I think the court, in orderly dispensing business, can proceed with them without any harm to the defendant. The court's going to allow you the presence of the jury selection expert, Spillman, so I assume that his comments would be more significant to you in the early stages than those in each bundle. So we'll proceed with that. Now, what other motions we have?
Well, the next motion we'd like to take up is the motion to prohibit further prejudicial extrajudicial statements by Sheriff and Sarah. Filed. We have a videotape here.
Is the sheriff here? I need to reliving what's already gone into. I think the court can simply say to this that
Judge, the last thing we're relying on something that happened last week. The court may not be aware of. We got a videotape of the president on it as we want to present on it.
are you ready to proceed? Sheriff, you want to come up and make sure that come over on. Take one of those chairs over there. Move that where he can see it for sure. Did you see this, Judge? You can move it out a little bit. That's fine. I tilt it just a little bit so Sheriff Sarah can see it also. Turn your card. I'll stand up. Be easier, gentlemen. You see it there, Sheriff? Back it up a little bit, gentlemen. All right, maybe we lost. That's good. Thank you. Without the presence of the jury, I don't have any objection. Thank you.
Well, we talked about personality traits, confinement, property that he has with him, what property in his cell now that may not be possible to have in the cell here, just those kinds of things.
Dade County Corrections Director Jack Sandstrom, who is in charge of security, says he's prepared for Bundy's arrival.
Oh, there's always the possibility of escape. Personally, I feel more concerned for his safety from some bizarre kind of situation than I do for as far as escape is concerned.
Law officials examined the single high security cell in which Bundy will be placed for the duration of the trial. They also took a look at the courtroom where preparations are already being made for the 3 to 4 week long trial. A special room has also been set up where Bundy, who is partially acting as his own attorney, can consult with his defense counsel on the progress of the case. The trial is set to begin this coming Monday. Ronald Lloyd, Channel 4 News.
Did we get the interview?
I think I might have missed the beginning, but run it back.
Security says he's prepared took place in the chambers of Chief Administrative Judge says he will come down to Miami sometime early next week to talk to Judge Cowart, jail officials, and police about security in this case. He says he has no intentions of giving the exact date when Bundy will be transported. Robin Lloyd, Channel 4 News.
His office when we're moving from Santos so that they won't have enough escorts taken over the floor.
It was the first time Dade and Leon County law officials had met to talk over what security measures should be taken to transfer accused murderer Ted Bundy to Miami. The meeting took place in the chambers of Chief Administrative Judge Edward Cowart, who ordered the change of venue a week ago because of the tremendous publicity surrounding the case in Tallahasse. Since the trial was postponed on June 12th, Bundy has been kept in a high-security cell in Leon County Jail. Local officials say he has made no attempt to escape. Bundy became known as an escape artist in Colorado after twice escaping from jail. Leon County Sheriff Ken Casares says his chief concern was to inform local authorities about Bundy's charm and intelligence, and how he uses those traits to try to place jail officials off guard.
Well, we talked about,
So we've seen,
our personality traits.
I've continued from where you were. Everybody please return to your feet.
Turning this over.
David Marcus.
All right, Mr. Harvey, what you move?
No, that's submitted to take a transcript of it, and I've outlined in the motion what I consider to be a continuing course of conduct. Sheriff Casares, what looks to be a deliberate attempt to try and poison the minds of no matter where we're going to have this. And I would ask the court, without further argument, to please instruct the sheriff to withhold any further prejudicial statements by our client to this case.
Do you have any response?
Well, yeah, of course, we respond, extreme objection to his statements about the sheriff's motives and intentions and purposes and whatnot. The man answers questions that are asked of him honestly in the press, and just because it's disseminated is something that has been a problem for all of us, and that's why we're down here in Miami, I think, because there has been so much press coverage. But we object to the way in which he's phrased his motion. We don't object to the court, of course, instructing as many people as possible to try to put this case on in a low-key fashion, and let's get it to trial and get it done with.
Mr. Key, with that specifically is the court's instruction. I do think that there are a lot of trying factors involved in the trial of the case that sometimes aren't in all cases. I think the best thing that all of us that can do that are intimately involved in this thing is just that. And we would ask all parties, include counsel, the defendant, state, everybody involved in it to maintain that particular position. And remember that a jury of peers are what we're trying to collect and select. And I don't find any necessity of entering a restraint order or a gag order. I just simply commend to them as constitutional officers and to all of you as constitutional officers to refrain from further comment or unnecessary comment about the case. Attempt to do just what I've said from the beginning, to let us proceed with the legal issues in the case and get them resolved. That's what we're here for. And I don't think we need to issue any further order, but I will issue that order, Mr. Harvey, that we all refrain from any further communications other than is necessary, and they be made in the courtroom. Now, that's one uniqueness of the proceedings that are taking place. Everything it transcribes here in the courtroom, of course, is front and center. And I don't think there is any need for us to further disseminate those things that we don't talk about in court. And basically, that's our idea. And I don't, by saying that, I don't communicate that some of the language that you said in your motion is a finding by the court that there has been anything willful, malicious, or that there's been anything that violates what he was supposed to do. I simply say that I think the time has arrived where we're going to try to move this trial through the positions of a trial. as fairly and impartially and without any disseminated prejudice on the part of anybody, so that we can give this young man the fair trial that we've labored pretty hard for and what we're all here for. I think with that, we'll dispose of the motion. Now, what are the motions you had?
Judge, we've got motion for additional preemptory challenges, which I understand the court granted us 25.
In the Tallahasse situation, it doesn't carry over.
That's what I anticipated. So we have filed a motion for additional preemptory challenges here also. And in support of that, we've subpoenaed a number of newspaper articles from the local media to be entered as exhibits. I'm not sure if we've got all of those exhibits at this point, or whether there are people here with the exhibits.
Well, let me explain to you that I am not going to deny you some consideration in getting a jury. That's one of the things that we've talked about at the beginning. The excessive number that I granted in Tallahasse was based upon the particular setting in Tallahasse. And when we begin to question some of these jurors, I will indicate early in the proceeding whether or not, and I think that's going to be the guiding factor in my mind, that I'll indicate to both counsel early in the proceeding if there is necessary in the concept of proceeding with fairness and impartiality that we grant additional. Now, I'd like to take this motion under advisement and rule on it when we see the sense of, I will say to you that if necessity mandates we give you additional charges, we're going to give them to you. I'm not going to be quite as liberal as I was in Tallahasse. I don't think the reason was that. But and I will tell you well in advance when we begin to preliminarily question some of these jurors, so that we can get a feel of what's there, similar to what we did in the motion for change of opinion. I think I can get it early in the proceeding and will allow you some additional necessity to make. I have a feeling you'll get them without using all the preemptory challenges that you have now, unless you just want to use them. All right. Let us see what necessity dictates, and I'll assure you that we'll do. If necessary, we'll give you some more. I think that we can get a better sense on that, as I said, if we proceed along.
Judge, attached to that motion, the judge is going to take it under advisement. I'd like the court to be aware that we have attached, Dr. Hesselbar has done a preliminary public opinion poll in day handling. I attached the results to the motion. I'd like the court to consider.
You know, I
I can't explain the statistics.